Okay, the next category, reforming criminal sentencing. There's two initiatives that I put in this category. The first is Proposition 5. Turn to my notes here. And the second is Proposition 9. Proposition 5 is basically an expansion of Proposition 36. It's intended to expand the access to the diversion programs that we set up under Prop 36. You may recall Prop 36 was passed by voters and it was designed for nonviolent drug offenders to be sent to rehabilitation programs instead of being sent to prison. And it was designed as a program that would allow those folks to get treatment, to get off their drugs, to get their lives back together, and not have to deal with the criminal record and the consequences of being in the penal system. There's been a mixed literature on sort of whether 36 did anything. Professor Hocken here has written the book literally on this initiative. The bottom line is the savings that they've talked about in terms of diversion last for a couple years, and then it starts costing you money, it turns out, because one of the things that the program has not been very good about is follow-up. If you look at the number of people who start the program and actually finish it, it's not a very large number. And because of that, the benefits of the program are never really fully realized. And you end up with a scenario where you end up spending a lot of money for these programs, you build the infrastructure for it. The second part of it has been accountability. Enforcement, if you fail to complete the program, has been lax at best. And offenders, if they just drop out of the program, so far there haven't been a lot of responses in terms of imposing the sentence they were supposed to have. So part of it is structural inside of Prop 36. This would actually add more people to that program and create a scenario where if someone commits a crime, if they argue, for example, they're committing a property crime to support their drug habit, and they don't necessarily even have to document the drug habit, then they can qualify for diversion into this program and avoid prison time. And that's really been one of the fundamental debates about whether this is appropriate. It also creates some new infrastructure. If we look at sort of the pros and cons, the same goals that existed in 36 exist for this population. You're trying to reach more prisoners and get them off of drugs. There's a savings by diverting these people from the prison population. I think prisoners cost just under $50K each a year to house, so we would like to do that. We also have some pressure in our prison systems associated with overcrowding. It also creates something that doesn't exist extensively now, which is a formal framework for rehabilitation of youth within the juvenile delinquency, the juvenile courts. Those things are available on a judge-by-judge basis, but there's no comprehensive system at this point. The challenge is, obviously, it'll create about $500 million of new spending each year. There is the risk that some violators will be able to manipulate this initiative and to get out of jail free, so to speak. There is some concern that if offenders fall off the program and there's no enforcement, obviously, that in fact they get back on the street immediately with no censure for what they've done. And then there's also the challenge that it actually reduces further the discretion of judges to make judgment about a defendant's history and choices and whether, in fact, incarceration or rehabilitation might be appropriate. Let's see. The no money from this has come from prison guards, as you might expect. They like having lots of prisoners. The yes money came mostly for George Soros. The yes side is outspending the no side about 10 to 1 at this point, about $5 million to $500,000. And again, that's September 30 numbers. A lot of the money comes in right now. Any questions on 5?
Does a no vote change Prop 36 in any form, or would it just still?
No, Prop 36 is already part of the I think 36 was a constitutional amendment or statute. I'm not sure, but it doesn't change. 36 is there.
The other large funding source for the yes side is the rehabilitation clinics, nurse associations, because obviously they'll benefit from more people going through the programs.
That's correct. Okay, the other criminal justice, and there's actually a third criminal justice initiative, Prop 6, which I'm going to come back to in a second. Prop 9. Prop 9 expands the Victims' Bill of Rights. Now, there was an initiative passed in I think it was 1982, that created the Victims' Bill of Rights. And it was an initiative statute. Now, when you qualify an initiative for the ballot, if you get more signatures, you can actually amend the state constitution. And what this does is it takes a lot of the things that were in the Victims' Bill of Rights, and instead of having them be statutes, which can be technically amended by legislation or by going to voters, it makes it part of the state constitution, which gives them sort of superseding authority over statute. So if the legislature passes a statute that's in violation, the court is no longer considering whether two statutes are in contradiction, but whether the second statute contradicts what would be the Constitution. The main thing, there's two really big things that this does. The first is it makes the restitution that's given to victims the priority expenditure of criminals and people convicted under the statute. In other words, if I have a judgment against you and the court decides to fine you because you committed a white-collar crime of some sort, the judgment that goes and gets paid to the victim has a priority over the payment of the fine. Right now, the fine actually has precedence, and so the state collects its money, and then the victims get what's left. This flips that order. So one of the impacts, one of the concerns is what impact will this have on the finances of the state if some of those fine revenues get diverted to the victims. But the really big thing this does is it gives victims a much more active role in the decision process about how to prosecute criminals. If somebody is a victim of, say, an assault, the victim of that assault they're required now, the prosecutor would be required before they cut a deal with the defendant to actually consult the victim. And right now they obviously don't have to do that. The other thing it does is it gives victims the right not to have to testify and provide testimony, a preparatory testimony like a deposition, to the defense side in a criminal trial. So if you've been assaulted by somebody, you don't have to then meet with their lawyers where they can ask you all kinds of embarrassing questions and sort of pursue you. And sometimes defense counsel uses this as a form of intimidation. So it creates some important protections. At the same time, as you can imagine, the other thing it does is if you're in the parole cycle, like you have a life sentence, it triples the amount of time between parole hearings. So right now it's 1 to 5 years, and it changes it from 3 to 15 years. Obviously, this is going to make victims' rights more important. It's going to require more notifications to victims. Right now, they have to notify you within 30 days if a parole hearing is coming up. They have to notify you at least 30 days before. It changes it to 90 days. So it creates more communication. There's a sense that you can protect the victims more. It also protects confidential information about victims, like bank accounts and addresses and such, from the people who created their victimhood. The arguments against it, obviously it duplicates existing law, it changes it from statute to constitutional amendment. There's a potential cost in this. It expands the number of people who can testify at parole hearings, for example. The biggest concerns have to do with it taking money from other programs. This probably, if you look at the LAO's analysis, will have a modest, if any, effect on cost. The other thing it's likely to do, though, is it's likely to keep prisoners incarcerated for longer periods of time because they have fewer parole hearings and opportunities. And it allows victims to bring more testimony to the table, which should, in the long run, allow them to serve more of their sentences. And that creates a direct cost in the correctional system. Organized labor has spent some money to try and stop this for that reason, because they don't want to see the money going to prisons.